The Coinbase channel is pleased to have you back. Which of these options do you prefer? Please people cast your vote in the community option. Option A XRP. Option B Ripple. Option C SEC. The attorney representing XRP abstained from accusing them of failing to defend their rights following a remark made by Coinbase Chief Legal Officer, Paul Grohl. Printing Suite ex-attorney John Deaton has slammed the U.S. Securities and Exchange Commission in reaction to Grohl's concerns over the SEC's repeated reference to currency investment contracts. Despite his admission that investments does not necessarily mean an investment contract, he insisted that any such document lacking a pledge to partake in the company's future profits or assets would be lacking in substance. He continued by saying that someone is not necessarily an investor simply because something is referred to as an investment. The position taken by the Securities and Exchange Commission in the Edwards case is consistent with this point of view. Investment contracts are perceived as having equity involvement similar to debt, according to John Deaton's response and criticism of the SEC's approach. A prominent amicus curiae in the Ripple Verve vs. SEC. A case, John, a former federal prosecutor, voiced his disapproval of the misogynistic attitude. He provided a thorough criticism of the measures done by the SEC in relation to the post that was published on X. Memoirs written by Deaton about his time spent prosecuting cases highlight the seriousness of the role and the privilege of serving the U.S. Regarding my background as an ex-federal prosecutor, it is anticipated that U.S. federal government solicitors consistently wear the white hat, as far as I am aware. I represent the United States in an open court, a statement that should give anyone the willies, as Deaton so astutely observed, is enough to do just that. Using examples from the SEC and DOJ's web pages from that era, he drew parallels. The fact that XRP was mentioned by a seasoned Wall Street financial expert highlights its promising future. The attorney who was in favor of XRP went on to explain how federal prosecutors should protect the rule of law and seek justice. Despite the usual drive for victory and competitive nature, federal prosecutors are supposedly bound by laws based on the concept of justice, says Deaton. This is true whether they are pursuing civil or criminal procedures. He did admit that these feelings ought to stem from a desire for fairness and a desire to follow the law. Preceding my speech was a privilege, and it provided more proof of the fundamental distinctions between lawyers representing public firms and those representing private companies like as Ripple or Coinbase. Also included are public prosecutors. The Department of Justice and the Commission of the Securities and Exchange Commission have ignored the privilege and honor that their clients represent, according to Deaton. He was informed that, unlike private attorneys, who are only obligated to protect their clients' interests, federal prosecutors should be guided by the rule of law and the idea of justice. Whether they are dealing with civil or criminal cases, federal prosecutors must follow the rule of law, says the XRP supporting lawyer. Their main argument should be that a lawsuit against XRP demonstrates dishonesty and inconsistency, he continued. Find out which Judge Net Byrne uncovered in the Ripple case. Deaton also zeroes in on the SEC's alleged double standards and contradictions. He used Net Byrne as evidence that SEC attorneys like Gerber Gruhl and Georgia Tenrero care more about advancing their agenda and winning arguments than they do about following the law to the letter. According to Deaton, there are numerous situations like the Ripple scenario where this problem occurs. The reverse is true. It is a central issue in many other kinds of legal conflicts, including ones involving grayscale. Regarding Warren's invitation to run for the Senate, Deaton, an XRP fan and Voyager bankruptcy and debt-bought reader, expresses his thoughts. This objection stems from Deaton's opinions and has been repeated by district and appellate court judges in other cases, such as Ripple Grayscale, Invalidate Your Bankruptcy, and Debt Box. Since SEC solicitors have abandoned their responsibility to honorably and dignifiedly represent the United States in court while maintaining the principle of justice, a federal judge may punish them for debt. Finally, he calls for the SEC to be held accountable in his address, implying that Gary Gensler and the SEC Enforcement Director 10 should be fired. There are a lot of intriguing names on Coinbase docket. One of them is January 17, 2024, when the company will submit a request for judgment and keep fighting the Securities and Exchange Commission in court. This comes after on December 15, 2023, Coinbase turned down the SEC's proposal for cryptocurrency regulation. This caused Coinbase to seek judicial review on December 18, 2023. The current price of one XRP coin is 5 cents. Ripple's, the chief technologist of Ripple, has dropped some startling new details about their XRP supply. David Schwartz, chief technology officer of Ripple's, recently tweeted some shocking information on the company's XRP holdings. Ripple wallet holders already have access to CRP, and XRP in escrow lockups is also subject to the ledger. Until escrow releases it once a month, Ripple cannot access the other XRP category. The bulk of the released XRP has already been returned to escrow, despite our best efforts using various tactics, such as lockup sales and XRP as a partner reward. Everything that did work was essentially equivalent to selling XRP, as we also found out. In response to a tweet from former user Mr. Huber on February 8, 2024, Ripple made it clear that it has options about its XRP holdings, including the option to maintain or decrease them. There is no other choice available, he continued. It was initially meant for Ripple to quickly decrease its XRP holdings, as Schwartz pointed out. He continued by claiming that he can't think of a chain reaction that would make this first concept even marginally credible. Optimists think the event might not be all that beneficial, even if it does take place. According to Schwartz, they had to stop the giveaways once XRP reached a market price, because individuals would spend money to gain them. According to him, the initial intention was to decrease the supply of XRP through giveaways. Ripple also considered a number of alternative strategies, including lockup sales and an XRP incentive for partners. For the first time, it became clear that selling XRP was fundamentally equivalent to all that worked. Schwartz claims that Ripple has been in operation for nearly 10 years and is well into its 5-year plan to resolve customer complaints around escrow and supply burning. During the close of the deal, Schwartz acknowledged that he was unable to make a decision due to his uncertainties about the escrow's merits. Additionally, Ripple's chief technologist voiced his displeasure of the plan to remove escrow supplies, implying that this strategy may not work. If you liked this, please subscribe, share, and give it an X. Goodbye for now.